So now what the law does and what the Department of Labor, as a result of the law, has done is identify specific elements that must be included in every New York State employer's sexual harassment prevention policy. The first of these requirements is that the policy must prohibit sexual harassment consistent with guidance issued by the Department of Labor in consultation with the Division of Human Rights. So the requirement to have the sexual harassment policy is based on an amendment to the New York labor law, but the actual prohibition of sexual harassment is in the human rights law, and those two different areas of law are governed by separate government agencies. So for whatever reason, this is what the state legislature decided to do, and as a result has required the Department of Labor and Division of Human Rights to work together in establishing the standards for these policies and the training that is also mandatory. What we don't entirely know is what this wording, prohibit sexual harassment consistent with guidance issued by these agencies, mean. Because what these agencies have done is issued a model policy that we will be discussing, and it's not clear how much of that model policy, if any of it, is actually required to be in any particular employer's policy. When it says prohibit sexual harassment consistent with the guidance, does that mean that it just has to say that we prohibit sexual harassment, or does it mean that you have to say everything else that the Department of Labor and Division of Human Rights want you to say? What we further know is that your policy must provide examples of prohibited conduct that would constitute unlawful sexual harassment. Presumably, there are no specific examples that must be included or must be excluded, except that there are examples in the state's model policy. So does that previous slide mean that those examples need to be included? Best guess is probably not, but that is theoretically an open question. Your policy must include information concerning the federal and state statutory provisions concerning sexual harassment, the remedies available to victims of sexual harassment, and a statement that there may be applicable local laws. So if you are using the state's model policy or have based your sexual harassment policy based on those policies, you'll know that there's a whole section towards the end of the model policy that says this is what the New York State Human Rights Law does, this is what the laws administered by the Equal Employment Opportunity Commission at the federal level do, this is what might apply if you're in New York City, subject to the New York City Commission on Human Rights' jurisdiction. And they also recognize that there might be other local laws, and in certain situations, you may want to report the behavior to the local police. So that is generally understood to need to be addressed, but again, there's open question as to how much of the precise wording that is used by the Department of Labor in creating their model policy you have to include in your policy. Most of you have adopted your sexual harassment policy in response to the requirement that you do so a few years ago. But the main reason we are bringing this up now is that the Department of Labor and the New York Division of Human Rights have recently issued a new model policy. So we are building up to talking about what those changes to the model policy are and what that might mean for your policies. You're probably all aware that the state required that you include a complaint form for sexual harassment. Technically, you don't have to include that with your policy. There is guidance that says as long as your policy makes it clear where that form can be obtained, So you don't necessarily have to attach it to the policy. If you, for example, say you can go to human resources to fill out a complaint form, and then the complaint forms are available for employees to pick up there. But I think most companies have just included a complaint form with their policy, which is what the model policy has done. You have to include a procedure for the timely and confidential investigation of complaints that ensures due process for all parties. I think if you had pre-existing anti-harassment policies before the state required a sexual harassment policy, you likely had some sort of discussion about reporting this, and then once it's reported, it'll be investigated, and then the company will take appropriate action. So clearly that's required for the sexual harassment policies at this point. Again, the model policy has certain language that suggests how that investigation is going to be done. It seems unlikely that employers are required to adopt that language exactly and the procedure exactly how the state has suggested it. But again, there's not a whole lot of certainty as to how far you can deviate from that, recognizing that the statute itself does require that some due process be ensured. The policy has to inform employees of their rights of redress and available forums for adjudicating sexual harassment complaints administratively and judicially. So I mentioned before that the model policy identifies the various laws and agencies. So here is the other side to the law piece, that you have to not only identify which laws apply, but which agencies administer them and what employees can do if they want to go and file administrative complaints with one of the agencies or go into the courts. The policy must clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against individuals engaging in sexual harassment and against supervisory and managerial personnel who knowingly allow such behavior to continue. So this isn't really that shocking of a requirement, that certainly if someone engages in sexual harassment, that should not be acceptable. And a key point of the state's requirements are identification that supervisors and managers must be told, and other employees must be told, that those personnel must report any information that might be sexual harassment. And if they don't, that in and of itself is the grounds for discipline. The policy must clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding involving sexual harassment is unlawful. Again, this is not really anything that novel or unusual. Someone who files a complaint of sexual harassment certainly has the right not to be retaliated against for filing that complaint.